Welcome. In this video we explain how a person can lawfully continue with an unlawful activity in terms of section 24G of NEMA. Welcome. My name is Sean McGregor of Ecoleges Environmental Consultants based in Mpumalanga, South Africa. And we're on a mission to empower all South Africans to protect their environment through the correct interpretation and application of our environmental legislation. So if you want to learn how our environmental law applies to you and how to avoid costly and unnecessary mistakes, if you want to increase your knowledge and skills to reduce your reliance on external consultants, if you need mentorship, or if you need to earn CPD points for professional registration, then you'll want to subscribe to this channel. You can do that by swiping your mouse over the icon to the bottom right hand side of your screen, and don't forget to click on the bell notification icon so that you can be notified the moment we upload a new video. If you do know of anyone else who can benefit from these videos, we would appreciate your support trying to help spread the message by liking them. Thank you. So let's get started. The title of this video is Making a Wrong Right, Section 24G. In terms of Section 49A1B, it is a criminal offence to commence with an activity in contravention of Section 24F1. Meaning it is a criminal offence to commence with a listed or specified activity without an environmental authorization. In terms of Section 49B1, a person convicted of this offence is liable to a fine not exceeding 10 million rand and or to imprisonment not exceeding 10 years. Unfortunately, many of these listed or specified activities, as well as their prescribed thresholds, the triggers if you like, are not taken into consideration before commencing with development for whatever reason. The net result is the unlawful commencement of a listed or specified activity. If it happens to be for a development that you want to pass on to your children and their children, then fortunately the National Environmental Management Act does make provision for a person to submit an application in terms of Section 24G to lawfully continue with that activity. Now notice I said to lawfully continue. The Section 24G application process will not rectify or authorize an unlawful activity. It can only authorize the activity going forward from the date that the environmental authorization is signed for the benefit of future generations or the continuation of that activity. In other words, by submitting an application in terms of Section 24G does not derogate the National Prosecuting Authority's legal authority to institute criminal prosecution in terms of Section 49A and B. Now there are three things that you should know before undertaking a Section 24G. Firstly, it is an entirely voluntary process. You have a choice. Secondly, I mentioned earlier, it applies to listed and specified activities that were commenced without an environmental authorization. It also applies to waste management activities that commenced without a waste management license. And thirdly, you will be liable to pay a compulsory administrative fine not exceeding 5 million rand before the competent authority may take a decision on whether or not to grant ex post facto an environmental authorization or waste management license. The Section 24G fine regulations published in Government Notice R698 on the 20th of July 2017 provides for the procedure to be followed and the criteria to be considered when determining a fine pursuant to an application submitted in terms of Section 24G of NEMA. A fine recommendations committee is established by the competent authority to make a recommendation to the competent authority about the quantum of the fine by taking such considerations into account as socio-economic, biodiversity and heritage impacts, as well as the compliance history of the applicant and whether or not the applicant is a firm or a natural person. The official application form in respect of Section 24G applications provides the applicant in Annexure A with the opportunity to make 3 representations. Firstly, in respect of the possible instructions given by the competent authority in terms of Section 24G1, such as immediately ceasing with the activity, assessing the impacts, and remedying any adverse effects. 2, in respect of why the competent authority should not defer the application in those cases where the applicant is under a criminal investigation. And thirdly, in respect of the quantum of the fine, specifically why the competent authority should not issue the maximum allowable fine of 5 million rand. Once these representations have been taken into account, the competent authority will then issue a final directive. Right, so what is the Section 24G process, or what does the process entail? Now, the following is our opinion, and it's taken from Section 24G of NEMA, read together with the Section 24G fine regulations of 2017. The first thing a person must do is undertake a public participation process, and that entails placing a preliminary advertisement into a local newspaper. It must also be published on that person's website if one is available. The person must open and maintain a register of INAPs, that is, interested and affected parties, and they must be given at least 20 days to register before submitting the application. Failure to do or undertake this public participation process before submitting an application constitutes an offence. Right, then you need to submit the application form. The application form will be prepared by an environmental assessment practitioner, and please don't forget to attach a copy of the INAP register as well as proof of the advert to your application form. Okay, the competent authority will then or may then direct a person to perform certain actions, including the compilation of a report. And the report must contain a description of the need and desirability, an impact assessment, a description of the mitigation measures, an environmental management program, a description of the public participation process that was followed while compiling the report, as well as potential specialist studies. And then again, don't forget to include a copy of the application form as an appendix to that report. The Fine Recommendation Committee will then advise the competent authority on the quantum of the fine, based at least on the information contained in the report and the application. The competent authority must then determine the fine and inform the applicant. Now, the applicant may, by written application, request for an extension of the time period within which the fine has to be paid in full. The applicant must also inform all registered, interested and affected parties of the determination within 14 days of its receipt, and then obviously go ahead and pay the fine. Only upon the fine being paid will the competent authority consider the report and then reach a decision, that is to issue or refuse to issue an environmental authorization. And that's it. Now, you may have noticed that I've actually been walking through or around, sorry for the painful grimace, a graveyard. Unfortunately, over the years, this graveyard has been expanded and expanded and expanded. And so eventually they would have exceeded the prescribed thresholds, specifically relating to the expansion of a cemetery in the listing notice, and required an environmental authorization, which has never really been undertaken. And so unfortunately this whole cemetery is an unlawful activity, at least from that date when they exceeded the prescribed threshold for expansion without applying for an environmental authorization. And so it will forever remain an unlawful activity, this particular cemetery, which is very unfortunate or sad. However, the opportunity still remains for the local municipality to apply for a Section 24G and at least then lawfully continue with the cemetery going forward. So thank you so much for taking the time to view this video. I hope it has been worth your time and helpful. For those who have joined the MP or Incourse tiers of our membership program, you will receive an additional video. We go through an official application form for a Section 24G application. It was provided to us by the Mpumalanga Department of Agriculture, Rural Development, Land and Environmental Affairs. We also propose an alternative option in certain circumstances should you not wish to pursue the Section 24G application process. For those who haven't joined our membership program yet, you're welcome to check it out on Patreon. Otherwise, if you're simply looking for a consultant to help you with a once-off project, you're welcome to visit our website. Please, I do recommend, check out our previous video up here. We explained a person's rights and responsibilities when it comes to dust control. Our next video over here, we explain what to do with your hazardous waste. Yes, you do have hazardous waste. Otherwise, subscribe, click on the bell notification icon. If you do want to help spread the message, you know of anyone else can benefit, please like these videos. Thank you so much, guys. Keep strong and God bless.